Shalom, this is Yah is Magnified, and I'm back with another informative video. Today's video is titled, If You Receive a Voice Message Like This. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth, nothing more, nothing less. So with that being said, I would like for you all to hit that like button. And also, if you're new to my channel, hit that subscribe button. And also hit that notification bell so you all can be notified as I'm dropping these powerful videos. So without further ado, let's get to it. Okay, guys, so what we have on the screen is in fact the voicemail that my aunt sent to me through text message that he received from the Office of the Attorney General. So we're going to go over the voice message in its entirety so you can hear exactly what the Office of the Attorney General is requesting from my ARC. So maybe this video can help someone or to prevent someone from making a mistake. Okay, so let's go over the voice message so we can hear exactly what the Attorney General is requesting. Let's go there.
I'm trying to reach Sherrod Yancey. Hi, this is Melissa McPhail. I'm calling from the Attorney General's office about your child support case. I work in service, and we're trying to get you served to move your case further. I was wondering if you would be interested in signing a waiver of service digitally. Please call me back at 832-591-3621. Thank you. Bye-bye.
Okay, so now, as you all just heard, the Office of the Attorney General is basically asking him to voluntarily receive service without them following procedural due process to properly serve him, okay? So now, let's go to Texas Rule, I think it's 119. Let's go to Texas Rule 119 so we can see what proper process of service is and what they are requesting him to do. Let's go there. Okay, so now, as you all can see, we're coming from casetext.com. And as stated before, we're going over Texas Rule of Civil Procedures 119. Let's pick this up at the top where it states Rule 119. And Rule 19 is pertaining to what? It's pertaining to acceptance of service. So you all can see, okay, highlighted in blue, acceptance of service. But let's continue. It reads what? The defendant may accept service of process or waive the issuance or service thereof by a written memorandum signed by him or by his duly authorized agent or attorney after suit is brought, sworn to before a proper officer other than an attorney in the case, and filed among the papers of the cause. As such waiver or acceptance shall have the same force and effect as if the citation has been issued and served as what? As provided by law. Okay, as it states in blue, as provided by law. Okay, so basically, once you accept waiver, so what the Attorney General want him to do is to voluntarily accept waiver from them so they can move the case forward. Because without him accepting service, they cannot move the case forward. But they want him to voluntarily accept to serve from him so they can move the case forward. But for do what? With an in turn, make it seem as though they followed the rules, even though they clearly violated his what? His right to procedural due process. And it's just that simple, guys. But let's continue on. It states right here, highlighted in blue, it states the party signing such memorandum shall be delivered a copy of plaintiff's petition, and the receipt of the same shall be acknowledged in such memorandum. In every divorce action, such memorandum shall also include the defendant's mailing address. Okay, so again, even in the divorce proceedings, they must follow the same steps. But it's not just for Texas, guys, it's for every state. Okay, every state has the same rules. So if you in North Carolina, South Carolina, Florida, Georgia, it's all the same. DC, Maryland, Virginia, Philly, New York, Jersey, it's all the same in every state, guys. Okay, so now let's go to what procedural due process is, because by him receiving, or if he was to voluntarily receive and waive his right to service, then he also raises what? His right to procedural due process. But in order for one to know that, let's go to the definition of procedural due process, for we know exactly what procedural due process is. Let's go there. Okay, so now, as you all can see, we're coming from Cornell Law School. Let's pick this up at the very top where it states procedural due process, highlighted in blue. Let's read it. It states, Top line: the United States Constitution requires that the federal and state governments abide by certain procedures to protect the essential interests of all citizens. The Fifth and 14th Amendment of the United States Constitution guarantees due process to all citizens. The amendments, also known as the Due Process Clause, protect citizens when the government deprives them of what? Life, liberty, and property. We know that child support deprives you of all three: life, liberty, and property, okay? Life is they come in and destroy your life straight up. The liberty is when they arrest you for failure to pay, and the property is the earned wages that you make every day or every time you get paid. But let's continue on. And limits the government arbitrary exercise of its powers. The United States requires two types of due process: procedural due process and substantive due process. As indicated in the name, procedural due process is concerned with the procedures the government must follow in criminal and civil matters, and substantive due process is related to the rights that citizens have from government interference, e.g., right to privacy. Okay, so those are the two procedural due processes. You have procedural due process and you have substantive due process. Okay, but let's continue. Let's finish reading. Pick up the top. It states procedural due process refers to the constitutional requirements that when the government acts in such a manner that denies a citizen of life, liberty, or property interest, the person must be given notice. So again, guys, just because you receive notice, there must be a proper form of receiving notice, okay? If they act outside of that form and you're receiving proper notice, then that's a violation of your procedural due process rights, okay? So that what the Attorney General want Mark to do. She want him to simply waive his rights to procedural due process and go straight to them depriving him of life, liberty, and property. But let's continue on. It states the opportunity to be heard and a decision by a neutral decision maker. The government must also demonstrate that there is an articulated standard of conduct for their actions with sufficient justification. The requirements called fundamental fairness protects citizens from unjust or undue deprivation of interest. However, the specific procedures guaranteed by the U.S. Constitution may depend on the nature of the subject matter of the interest in question, as well as each individual circumstance. In the article, Some Kind of Hearing, the famous Judge Henry Friendly provides a list of due process elements for a fair hearing. Judge Friendly's list remains highly persuasive to this day. The list goes as follows. So this is the list, guys. You all can pause it and read the list if you want to, but these are the 10. Okay, pause it and read it. But let's continue on. It states, in most cases, we examine the fundamental fairness of the government's actions to determine whether the government has met the requirements for due process. The criteria for determining whether due process requirements have been met depends on whether the particular government action concerns a civil or criminal proceeding. Specifically, in civil context, the courts utilize a balancing test between private interest, the government public interest, and the possibility of the government procedures erroneous deprivation of private interest and evaluating government conduct. On the other hand, in criminal procedures, the court looks to whether the procedures the government has adopted is offensive to the notion of fundamental fairness for due process analysis. The analysis for due process is thus inquiring more narrowly for criminal procedures. So again, guys, they was trying to deprive him of his procedural due process. So we're going to go back now to the test matches so if I continue going over the test matches and you all can read what my ox stated. It was funny to me. Hope you all get a good laugh out of it as well. So now let's go to the remainder of the test matches and then we'll close out from there. Let's go there. Okay, so now again, as you all can see, we're back at the test message. So that's him sending me the voice message. Now I said, Shalom, Mark, do not respond and do not sign anything. He said, no, I'm not, Mark. Just surprised they called me sounding like idiots, right? So I gave him the smiley face and I said exactly with the face palm because that's exactly what they sound like, straight idiots, guys. But, that's all I'm going to do for the day. If you all need my help, hit me up in my email at y'allismagnified@gmail.com. Let's get this right wisdom, this right knowledge, and this right understanding. More testimonies coming, guys. More powerful videos coming in the near future. Be on the lookout. And for those who haven't watched my last video pertaining to the update on the appeal, go back and watch that video. That video is up and available. And all my last videos that I've been posting. I know YouTube haven't been sending out notifications to a lot of you guys. But, I know I'm shadow banned, but I'm gonna keep applying pressure no matter what until we break the internet. So let's keep it going, guys. Again, if you all need my help, hit me up at my email at y'allismagnified@gmail.com. And with that being said, I say shalom.